The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to Unlocking the Secrets of Debriefings, a Paleromaza webinar. Today's slides can be downloaded from www.paleromaza.com/presentations or from the Handouts tab on your GoToWebinar dashboard. My name is Megan Connor. I'm a partner here at Paleromaza, and I'm joined by Julia Vito. She's an associate in our government contracts practice. We're going to be talking to you about debriefings. And I checked today, Julia and I together have over 50 GAO decisions on the merits, GAO protest decisions on the merits. And considering how many decisions actually go to the merits at GAO, that indicates to me that between us, we probably have done hundreds of protests. So we are definitely ready to talk about debriefings. But first, let me tell you a little bit about Paleromaza. We are a full-service law firm with offices in Washington, D.C., and Boulder, Colorado. We are most well known as a government contracting firm, and for 25 years, we have helped our clients navigate the complexities of doing business with the federal government. We also provide a full range of legal services, including advice on corporate, labor and employment, SBA procurement programs, and litigation matters. Our clients value the diverse array of legal guidance they receive from us and our responsiveness as we guide their growth and secure their success. So as I said, we'll be talking about debriefings. We think that this is going to be roughly 30 or 45 minutes, so we'll save lots of time for questions at the end, and feel free to submit questions as we go. What we're going to be talking about today is, when is a debriefing required? What are the mechanics of the debriefing? What can you expect to hear from the agency? What do they have to tell you, and what do they not have to tell you? We're going to talk about the new DoD debriefing rules as a result of the NDAA. We're also going to discuss how to make the most of your debriefing. We'll touch on some common misconceptions, and as I said, we're going to leave room for questions at the end, but please feel free to submit them as we go. And if for whatever reason we don't answer your question, please feel free to email Julia and I. Our email addresses will be at the end. They were also on the beginning slide with our pretty pictures. And with that, here is Julia.
Thanks, Megan. So the first question that we're going to talk about today is, when is a debriefing required? And this comes up in many situations, but the question is often triggered by receiving either a pre-award notification or a post-award notification that essentially tells you that you have not been successful in pursuing a government contract. So in the pre-award situation, when you get a pre-award notification, often that is due to the agency telling you that you've been excluded from the competitive range. So the agency has evaluated proposals. They've determined that some set of proposals are within the most advantageous to the government, and some they're just not going to consider anymore. So they have established a competitive range of proposals they're going to continue to consider. And then if you're getting this notification, that means that you are not within that competitive range. And the question of whether a debriefing is required at this point, the answer is yes, if you timely request a debriefing. And we'll talk later about how to go about requesting a debriefing. There is another kind of pre-award notification, and this can come in procurements that are set aside for small businesses or hub zone businesses or veteran-owned businesses, any kind of small business program set aside. The agency is supposed to notify offerors of the apparent successful offeror before actually awarding the contract. And this gives the unsuccessful offerors the opportunity to file a size or status protest of the apparent successful offeror. The thinking being that if that protest is successful, the agency will not actually make the award to that company. So if you receive one of these pre-award notifications in a set-aside contract, this is not a time where a debriefing is required, because the agency has not actually made a decision to award the contract to anyone yet.
I just want to jump in real quick, Julia, and an easy way to think about it is a debriefing for a pre-award notice. You can request one when the notice deals with you and you are no longer eligible for award. But if the notice deals with another offeror or another bidder and indicates that they may be in line for award, you don't really have a right to debrief then. That's strictly within FAR Part 19 and the small business rules.
Thanks. So turning to the post-award notification situation. So this is when the agency has actually selected an offeror or multiple offerors for award, and they're notifying you that you're not a successful offeror, or they've notified you that you are a successful offeror. And in these situations, whether a debriefing is required depend on what kind of procurement it was. And we segregate the types of procurements based on the FAR part that applies to the procurement. So the first part that we're going to talk about is FAR Part 15, and this refers to negotiated contracts. These are just regular old vanilla contracts. They can be IDIQ contracts. If you're thinking of the most, I would say most common type of contract that the government awards, they're usually going to fall under FAR Part 15. And in this situation, a debriefing would be required if it is timely requested. Under FAR Part 16 procurements, these are procurements for task orders under multiple award contracts. A debriefing would be required if the order exceeds $5 million. Otherwise, if it's lower than $5 million, a debriefing is not required. Under a FAR Part 8 procurement, this is a GSA schedule order or federal supply schedule order. A debriefing is not required. An agency can provide you a brief explanation of award if it is timely requested, and if the order requires a statement of work. But otherwise, you're not going to get a formal debriefing under a FAR Part 8 procurement like you would in other procurements that we've been talking about. And the last type is FAR Part 12. This is a procurement for commercial items. And typically under FAR Part 12, it is not required to do a debriefing unless the agency relies on FAR Part 15 procedures. So it's a typical way to figure out whether the agency is using FAR Part 15 is if you look in the solicitation if there are references to FAR Part 15, if when the agency gives you the post-award notification that you're not successful, if they reference debriefings under FAR Part 15, then a debriefing would be required if you timely request it.
And I just want to jump in and give a very lawyer observation that when I have clients tell me, well, it's in the FAR, but it's not in the CFR. I've had people tell me that before. The FAR is a component of the CFR, of the Code of Federal Regulations. The FAR is Title 48 of the CFR. So all these FAR parts, it's 48 CFR Part 8, Part 12, Part 15, Part 16. It's often then shortened to FAR 8, FAR 15, but I just wanted to add that lawyer observation.
All right, so if you've already figured out that the agency is required to give you a debriefing if you request one, how do you go about requesting a debriefing? So in a pre-award situation, and this is true of both pre-award and post-award, you need to request a debriefing in writing. So typically an email to the contracting officer will suffice. And in a pre-award situation, you must request a debriefing within 3 days after you receive the notice that you're excluded from the competition. If you timely request it, then the debriefing will happen as soon as practicable, which is, it can be any time, basically, that the government decides is appropriate. The pre-award debriefing can actually occur post-award, but we'll talk about later that that might not be the best option for you if you want to pursue a protest of the agency's decision to exclude you from the competitive range. If you are excluded from the competitive range and you receive a pre-award notification, you can't ask for a debriefing later after award if you haven't requested one when you learn about the exclusion in a pre-award situation. So if you want a debriefing at all of the decision to exclude you from the competitive range, you have to request it within 3 days of when you receive the notice. So in the post-award situation, again, there's a 3-day time limit, so you must request a debriefing within 3 days of when you receive the notice of contract award to the successful offeror. The debriefing is supposed to occur within 5 days of your request, but only to the maximum extent practicable. So this gives agencies a lot of flexibility to set the schedule in case they are overwhelmed by a lot of requests for debriefing. And the debriefing date can have a significant impact on the timing of a protest that you file after you receive the debriefing. So in general, in a situation where a debriefing is required, a protest can't be filed until you receive a debriefing that you've requested, and then the due date for the protest would be 5 days after you receive a required debriefing, or 10 days after you receive the notice of award, whichever is later. And because the timing of these debriefings can be flexible, it's a good idea to take one of the first dates that are offered to you for a post-award debriefing, because the protest deadline will not be extended indefinitely. If you ask for a debriefing, the agency comes up with some dates when they're offering to do the debriefing, and if you just say, no, I'm not available that day, that is not good enough to extend your timing for filing a protest.
And I just want to add that when we say days here in this context, we mean calendar days, but we will be talking about business days and a business day timing rule in a second.
All right, so you have found out that a debriefing is required. You've successfully requested a debriefing. So now once you actually get the debriefing, there are certain requirements of what the agency must tell you. So in a pre-award situation, the agency is supposed to tell you about their evaluation of the significant elements of your proposal, a summary of the rationale for eliminating you from the competition, and then they're supposed to give you reasonable responses to relevant questions to your situation, as in why you were excluded from the competitive range. If you receive a post-award debriefing, there's different information that the agency will provide you. The agency will tell you the significant weaknesses or deficiencies in your proposal, the overall evaluated cost and technical rating of you and the awardee. They'll talk about your past performance information, the overall rankings of offerors if it's a type of procurement where rankings are decided. Often in a best value procurement, the agency does not rank offerors, so they won't tell you that. They'll provide you a summary of the rationale for award, and then again, they'll provide reasonable responses for relevant questions. And I'll add that in a procurement for commercial items, if an agency does provide a debriefing, they will also provide you the make and model of the item to be delivered by the selected offeror. All right, now there are restrictions on what the agency cannot tell you in a debriefing. Contractors often think that they're going to get a lot of juicy information out of a debriefing, but there are some limitations on what the agency can tell you. So in a pre-award situation, the agency is not going to tell you the number, identity, ranking, and evaluation of other offerors, or the content of their proposals. And that last piece, the content of their proposals, that applies to any kind of debriefing. An agency should never be telling you what is in someone else's proposal. Also, in either a pre-award or post-award situation, the agency is not going to tell you trade secrets, privileged and confidential manufacturing processes and techniques, privileged and confidential commercial and financial information, and then the names of the people who provided the past performance references. They won't tell you any of that information. So the format of the debriefing is fairly flexible. It can be oral or written. Sometimes it's both. If you have an oral debriefing, the agency will also give you some kind of written information. It can be an in-person meeting or just a telephone conference, or neither. It could just be an email with some written debriefing information. The debriefings are usually led by the contracting officer, but often if you have a phone or in-person debriefing, other people from an agency will be present. The other people who are involved in the evaluation. And we often have clients ask us whether attorneys should be present or involved in the debriefing. And that's up to you, but occasionally agencies will be less forthcoming if they know that attorneys are either on the phone or in a meeting. Sometimes they can be more candid with you if it's just you and other people from your company as opposed to attorneys. So that's just something to weigh against the maybe it could be more efficient to have your attorneys present if you're going to turn around and tell them everything you learned in a debriefing because you're considering filing a protest. All right, so since last year's National Defense Authorization Act, the NDAA, imposed new rules for Department of Defense debriefings, we wanted to talk about what the NDAA said, and then also there's been a recent bar class deviation for DoD procurement, so we wanted to talk about that. So the NDAA said that for procurements over $100 million or $10 million for small business procurements, the agency should release the redacted source selection award determination if requested by offerors who are receiving a debriefing. So this is a big deal, and I should say this part of the rule has not actually been implemented yet because there have not been changes to the FAR or the DFARs yet. But once this goes into effect, offerors can get a lot of hopefully helpful information about how the agency made their decision to select someone else for award. Additionally, under the NDAA for DoD procurements, debriefings would be required for all awards over $10 million. This would include contracts and task orders, so not just contracts. And then finally, the NDAA required that responses to written questions submitted within 5 days after a debriefing took place, the agency would provide responses to those questions. And that leads us to the new DoD FAR class deviation, which was recently issued and is now effective, has been effective since March 22nd. And this says that unsuccessful offerors can submit written questions within 2 business days after receiving a debriefing, and then the agency will respond within 5 business days. And the key piece of this is that the debriefing will stay open while the agency responds to these questions. So I mentioned earlier that a protest has to be filed within 5 days after a debriefing happens, but if, in this case, the debriefing would stay open while these questions are being answered, and then a protest would be due within 5 days after the debriefing closes, which is when the agency would respond to those questions.
And this is confusing because we're referring to 2 different types of days. So 2 business days to submit your questions after you receive the debriefing, 5 business days for the government to respond to those questions, but then 5 calendar days to file your protest in order to get a stay of the awarded contract. The timeliness deadline, to confuse everyone even more, is actually 10 calendar days for GAO, but in order to get that stay of performance, which is so valuable and acts as leverage when you're filing a protest, it's 5 calendar days. So we've talked about what they're allowed to tell you in the debriefing, what they're not allowed to tell you in the debriefing, what the format can be. Let's talk about how to make the most of your debriefing. So when you first receive that notice, whether it's an exclusion notice, the pre-award notice, or it's a post-award unsuccessful offeror notice, go back to your proposal and do another red team review and compare it to the evaluation criteria and see if you can identify where you could have fallen short. And this is a good time in the process to involve some of your folks who were not in the weeds doing the proposal, because like all of us, sometimes we get too wedded to our work and we see all the perfections in it and not necessarily the imperfections. This is the time where you need objective business decision making. So do an analysis of your proposal and see if there were any shortfalls that you can identify before you go into that debriefing. If you have the benefit of an oral debriefing, whether in person or over the phone, you want to identify the right attendees. It should be at least 2 people, And again, if you want to have it, the guy who wrote the proposal, whether that's your director of BD, your VP, whatever the title may be, that's fine. But have someone else who's a little bit more objective involved as well, at a minimum. And Julia touched on whether to have an attorney involved. Generally speaking, it's not something that we advocate, but we are prepared to go, and we both have attended debriefings with clients in the past. Of the attendees, designate at least one of those people to take detailed notes throughout, again, if it's an oral debriefing. Those notes are all that your lawyers will then have to come up with your protest, should you decide to protest. So make sure that those notes are very, very detailed. Prepare questions in advance. Again, if you do this evaluation of your own going in, you should have some sense of questions you want to ask in that moment. And then obviously Julia touched on the ability to ask questions afterwards as well. And that's that last bullet. Outside of the world of the DoD, every other agency, if something came up in the debriefing that you need clarification on, submit the question or questions and ask the contracting officer to consider responding to them, and ask the contracting officer to keep the debriefing open. That's the magic word, open, and you want this in writing. The most important bullet, though, is the don't argue, don't accuse, just listen carefully. You're not going to make your case in your debriefing. The decision has already been made. So don't go in there thinking you're going to change anyone's mind, because you're not. If the minds will be changed later in the process should you decide to pursue it. So, and remember that this is also a client relations opportunity. It's a learning experience to see how you can improve on what you've done and retain this hopefully important customer relationship. So be mindful of the approach that you take and the tone that you take in your debriefing. So I mentioned some common debriefing questions. Sometimes this comes up in two forms. Either the agency says, okay, we're going to have an in-person or over-the-phone debriefing, in which case you want to have your questions ready, or you receive that unsuccessful offeror notice, and before you receive the written debriefing, you want to try to get some questions submitted, if you can. So some of the common debriefing questions that we recommend are obviously, what was your technical rating? What was your evaluated price and cost? For an LPTA procurement, where did your company rank and is your price the second lowest? This is important for a protest should you decide to pursue one. For a procurement requiring realism, was a realism analysis performed? If so, what was this process? How do you know if your procurement required realism? Do a search for the word realistic or realism in the evaluation criteria and see if they were required to look at whether price or cost were realistic. Does the agency have any recommendations for your future proposals? Was your proposal assigned any weaknesses? If so, what were they? And then this is one that Julia made me add about the definitions of ratings. Oftentimes, agencies will use ratings like excellent, outstanding without defining them in the solicitation. And for us procurement lawyers, when we then go in after the fact and try to draft a protest, we're trying to make arguments about a rating that you should have received, and we don't really know how that rating is defined. So it is helpful for your lawyers to have the definitions of the ratings, again, if you decide to pursue a protest. Now, when you're preparing these debriefing questions, if you are the unsuccessful offeror, then you're preparing these questions with an eye towards filing a protest. So let's look at what the most prevalent reasons for sustaining protests in 2017 were, according to GAO. The first one was an agency's unreasonable technical evaluation. And the case that GAO cited happens to be a case that Julie and I worked on, called CR/ZWS LLC. In that case, GAO found that the agency failed to find the awardee's proposal unacceptable, where its technical proposal failed to satisfy the minimum requirements of the solicitation. There's also cases were sustained based on unreasonable past performance evaluation, unreasonable cost or price evaluation, inadequate documentation of the record, and a flawed selection decision. I got to tell you, these are pretty unique reasons for sustaining protests, and I'll tell you why. the unreasonable technical evaluation, unreasonable past performance evaluation, unreasonable cost or price evaluation, in the last bullet, flawed selection decision. These are all in the realm of the subjective decision making that agencies inherently have in making these award decisions. GAO, prior to last year, very rarely sustains protests on these grounds. They more often in the past have sustained protests where procedurally the agency has taken a misstep, like the inadequate documentation of the record, where there's something very objective in the record that the agency or that GAO can point to and say, agency, you didn't do what you were supposed to do, you didn't document the record. Or another very common one is discussions. Anytime that the agency engages in discussions with offerors, it opens itself up to a potential protest later, because discussions tends to be, very fruitful fodder for procurement lawyers to make a protest argument. But these other areas, essentially the unreasonable evaluation grounds, it indicates to me that agencies are not doing a good job documenting their evaluations and the reasons for making their choices. And it also indicates that maybe agencies are trying to fight these protests instead of taking corrective action, and they really shouldn't. They should be taking corrective action. I have a theory that this could be in part tied to the retirement of more senior, experienced contracting officers, and this new class of contracting officers coming up is still learning the ropes and learning how to document the records. But it could also be mandates from agencies: never take corrective action, never say die, fight to the end, and then lo and behold, we get some sustains. I want to go back to the case that Julie and I worked on, this first bullet. That was an interesting one because the debriefing itself that we received in that case was not very extensive. But we were able to make arguments about the awardee that ultimately led to us getting the awardee's proposal and discovering in the agency's evaluation of the awardee that they didn't apply all the criteria. And that's ultimately where we won. But it just goes to show you that sometimes the debriefing can lead you on a path that you don't really realize is going to be a successful protest argument, and then it is. Now, this is something that people don't always recognize, and I thought it was important to put in our presentation for today. Again, because whenever you talk about debriefs, you're talking about bid protests. And that is GAO's bid protest statistics. This happens to be for the past 5 years. Last year, there were 2,596 cases filed. So that's how many protests were filed in fiscal year 2017. Of those, only 581 went all the way to decision. That means over 2,000 cases, protests that were originally filed, went away, never went to formal decision by GAO. So where did those 2,000 cases go? Some of them were dismissed. Maybe they were untimely. Maybe they were speculative. More likely than not, they went away because the agency took corrective action. So just keep that in mind, that if you file a protest, the chances of you getting to a decision are highly unlikely. It's 500 out of 2,500. So of the ones that went to decision, of the 581 that went all the way to decision, only 99 protests were sustained, meaning GAO said, protester, you're right, the agency did something wrong. 99. So GAO says that's a 17% sustain rate for 2017 because that's 99 out of 581. But if you look at the cases filed, 99 out of 2,596, it's more like 3%, a 3% sustain rate. So just put this all in perspective when you get your debriefing and you're weighing whether to protest or not. Just realize that ultimately the odds are not in your favor. What is most likely to happen is corrective action, and what the result of that corrective action is hard to say. So what to look for in your debriefing? This speaks more to a written debriefing, and I know a lot of agencies now are doing PowerPoint slides and slide decks. So how detailed and well documented is the debriefing? Is it scant? Is it just a page or two? Or is it, pages upon pages explaining the agency's rationale? Are there any mistakes in the debriefing? For instance, a reference to your technical proposal that is wrong. Now, I will tell you, Julie and I had a case recently where there was a blatant error in the debriefing. And when you put the debriefing next to our client's proposal, it's egregious. because you can tell that the statement in the debriefing had no basis in what was actually in the proposal. We filed the protest, but in filing the protest, we assumed that the agency was going to come back and say, oh, that was just a mistake in the debriefing. Don't worry about that. Here's what we should have said. You don't have any basis for this protest. What actually happened was the mistake in the debriefing is based on a mistake in the evaluation document. So we think that we have a pretty good protest. But that's why finding those mistakes in the debriefing and the summary of what they've done, that's so important for your lawyer. How were you rated vis-a-vis the awardee? Because that's going to be a consideration in the strength of your case should you decide to go forward. And how does your price or cost compare to the awardee? Again, that's something that we weigh when we want to protest. Some common misconceptions. Yes, we had a question earlier. Yes, awardees may request debriefings, and you should. I mean, it's supposed to be a learning experience, and so even when you win, there are probably things that you could have done better or even betterer. So it's always good to ask for one. They are not just for protests. We have clients call us all the time to complain about their debriefing. It's not coming, or it's so late, or it doesn't tell me what I want it to say. We can't protest that. GAO and the Court of Federal Claims have both said those are within the discretion of the agency. You are not entitled to a point-by-point comparison in your debriefing. You are not entitled to information on the evaluation of all the offerors. If you are an unsuccessful offeror, you are entitled to information about you, and you are entitled to information about the awardee. Not everything about the awardee, but certainly their price and their ratings. Allegations of bias are rarely successful. I can't tell you how many times we've had clients call us up and say, well, obviously the agency went with this company because they like this company and they really don't like ours because we hire Joe, and it goes on from there. Not successful. I mean, I had a case one time where an owner of the awardee was a government employee. And we also determined or alleged that the evaluators had a personal relationship with this government employee. We did not win on bias. So it's very, very difficult to prove bias. And waiting for your post-award debriefing after exclusion from the competitive range is not helpful. So if the agency gives you an option, if you receive that notice that you've been excluded from the competitive range and the agency says, we can give you a debriefing now or we can give you a debriefing after award, it's tempting to say, oh, I'll take the debriefing after award because I'll have more information in that debriefing. But it's not helpful for your protest. Your protest is going to deal with your exclusion from the competitive range. It's going to have nothing to do with the awardee. You won't have any standing to make any allegations about the awardee. So waiting for that debriefing is not often helpful to your case overall. So what do we look for when as a lawyer, when our client emails us or calls us up and says, I just lost this award, here's the debriefing that I received. In a best value procurement, it would be ideal if, from our perspective, and chances of success of winning the protest, getting that sustained from GAO, if the potential protest is the higher rated or lower price than the awardee. When we have clients approach us and they are lower rated and higher priced as compared to the awardee, it can make the protest difficult, and not because, generally speaking, allegations that the agency didn't evaluate you right is not going to get you very far. Now, I say that even though a couple slides ago I just showed you unreasonable evaluation were the three most dominant and prevalent reasons for sustainment last year. But generally speaking, there's tons of case law, both the court and GAO, that says mere disagreement with an evaluation is not enough. We've got to show more. So we ideally are going to have a protester that is higher rated than the awardee or lower priced, ideally both. In an LPTA, on the other hand, if there's just one possible award, the agency said we're making one contract award and that's it, then we hopefully have a protester that has the second lowest price. If that company does not have the second lowest price, then maybe they have the fourth, fifth, whatever the case may be. We need to be able to knock out all the offers in between. So if you are ranked price-wise number 4, if you don't have a way to knock out the acceptability, technical acceptability of number 2 and number 3, along with, by the way, the awardee, ultimately your protest is probably going to be dismissed by GAO. Because GAO is going to say that you weren't prejudiced because you were not in line for award. If the rationale for award in the debriefing is sparse, on the other hand, that can be very good for protest. That could suggest to us that the agency did not do a very good job documenting its decision. Remember, that was one of those bullets on the GAO sustain slide. Inadequate documentation of source selection. So if the debriefing sometimes is a reflection of that. So if we get a debriefing that, is 2 sentences long, that could be an indication that the agency didn't do a good job. Now, having said that, sometimes it means nothing, because sometimes we'll get a 2-sentence debriefing and then we'll get the evaluation record and it's 20 pages long. So sometimes the debriefing isn't a sign of anything, but sometimes it can be, and we've seen that bear out to some extent. And lastly, I mentioned discussions. Prior to 2017, discussions is normally up there as one of the reasons for sustaining a protest. So anytime we see that the agency engaged in discussions and the potential protester made changes in its proposal as a result of these discussions, which ultimately led to the protester being the unsuccessful offeror, that can be a good area to explore for purposes of a protest. All right. So before we start diving into the questions that we've received, here, again, my name is Megan Connor. I'm with Julia DeVito. Our email addresses are on the screen. Please feel free to reach out to either one of us. And now, Julia, let's hit some of these questions. So I'm clicking over here. I'm going to scroll up and start at the top. So, will offerors always be notified of award status, i.e., does the agency have a requirement to notify all offerors?
The answer is yes. If you've submitted a proposal, they have to notify you whether you are successful.
Okay, next question is, what if an agency sent a timely notice, but that person has left the company? Any recourse back to the agency if the company finds out on day 4 or beyond? The answer is no, because it's on the offeror to update its point of contact information with the agency. Will we send the slides after the session? I'm not sure, but if you go to the handouts tab in your GoToWebinar screen, they are right there. Is there a limitation on maximum extent practicable? We've proposed to one office where they've waited months to make a debrief available. That goes to the no, you can't protest, slow debrief. You can complain. I'll tell you what we've done in the past. This was a little sneaky. I won't identify the agency, but we did a protest for client A against agency. We got to know the agency attorneys involved, and they were very nice. A couple months later, totally unrelated client B, called us up and said, this agency is being very slow in getting us our debriefing. Can we protest this? We said no, but we can reach out to the procurement attorneys at the agency. We have a good relationship with them. So that's what we did. We called the agency attorneys and said, hey, can you help us out? This contracting officer is kind of slow in their role on getting us the debriefing. And lo and behold, we had it within a couple of days. So we were able to do it through back channels. Is there a formal way to make it happen sooner? No, but there could be a possible back channel way of making it happen. On slide 6 are the days, calendar days or working days. We talked about that. Can you ask for a debriefing even if you win the award to gain more knowledge about the award?
Yes, Megan mentioned that as the successful offeror, you can ask for a debriefing, and you should, because you can get more useful information.
Okay, then someone submitted a question where they received their letter with the sentence, you will be provided with a notification after final selection has taken place and may request a debriefing at that time. Could we have insisted on our right to a pre-award debriefing? I think I'd need to see that letter and how it's styled. What do you think?
It sounds like a pre-award notification in a set-aside contract.
That's what I'm thinking too.
And in that case, there is no selection of a a successful offeror. So the notice is right that you are not entitled to a debriefing at that time.
But once there's an award made or a notice of award, then you could request one. We have contracting officers that will read the debrief. It has been clearly scripted, but they will not provide it to us in writing, nor will they allow us to record the meeting or call. This makes it really hard to try to write everything down that they're saying, and we keep stopping them to repeat themselves. Is there anything that would compel them to provide it in writing?
Unfortunately not. The format of the debriefing is up to the discretion of the agency. So you can ask them to provide you something in writing, but there's nothing that would guarantee them or force them to give you something in writing.
Okay, here's one. Can you tape the debriefing? You could ask the government if you can tape the debriefing. I think I know what the answer is. And just, this is not my area of law, but anytime you want to tape any conversation, you should always get consent in advance. Is the government required to provide their independent government estimate?
No, that is something that's proprietary to the government, and that's not on the list of the things that they are required to provide you. And I would be very surprised if they did provide it to you.
Although I think I've seen one or two, a handful where I have seen it provided before, but I can't remember the context if it was to try to eliminate a realism argument. Why is this called a class deviation? I think this was with regard to the updated enhanced debriefing where in DOD you can submit questions. It's a FAR class deviation. It's FAR terminology to say that for purposes of DFARS, the Defense Federal Acquisition Regulation Supplement, that they are not following what is the traditional FAR 15505 and 15.506 with regard to the timing. That debriefing, the day-to-day debriefing is it. What they're saying instead is debriefing plus 2 business days to submit questions plus 5 business days to get those questions answered. Do you know if the VA plans on following the same 1018 NDAA requirements for Q&A after a debrief?
I've not heard that any other agencies other than DOD are planning to make these changes, but I think if it's successful for DOD, that other agencies might follow suit.
And by successful, Julia means fewer protests.
Yes.
So then someone said, just making sure in writing means email. Yes, in writing means email. Did you say that the new DOD debriefing regulations have not taken effect yet? If so, when are they expected to be implemented?
So the only rule that's in effect right now is the one about asking questions after the debriefing. The class deviation is in effect right now. The other rules that we talked about, particularly about the redacted source selection decision document, that is in the 2018 NDAA, which is a statute, but it has to be implemented into the FAR, and that has not happened yet. And I don't know that we've heard of a timeline when that actually will happen.
What % of DOD protests are sustained? I don't know that exact figure, but I would imagine it's very close to GAO statistics because DOD is the biggest spender, and therefore I have a strong suspicion that they have the most protests of any other agency. So I would say it's roughly 17%, or using my real math of 3%. And in fact, the case that I keep referencing that Julia and I had sustained last year, that was a DOD procurement. If the government is not allowed to discuss other proposals, evaluations, rankings, it is difficult to receive information about your proposal's rank to determine ability to protest. How can this be asked to force a response?
Well, in a best value procurement, it is very difficult to determine how your proposal stands with respect to the awardee and other offerors. So I think you just have to try to gauge on what the overall rankings are, or ratings are, if you are close to those, or you think your proposal should have been rated close to those, and if your price is lower, that can indicate that you might be close to next in line for award.
This is just going to be like a rough rule of thumb that will have multiple exceptions, but generally speaking, if your technical ratings are 2 or more ratings lower than the awardee, and if your price is significantly higher, let's just say roughly 20% higher than the awardee, those are 2 very high mountains to climb in a protest. So for instance, if the awardee was exceptional across the board and with a $40 million price, and you were simply satisfactory with a $60 million price, you have two huge strikes against you as far as GAO protest case law is concerned. Are you only allowed to protest if your price is the second lowest? In an LPTA procurement, unless you can knock out everybody between you and the awardee, yes, you are going to very likely have your protest dismissed if you are not the second lowest in an LPTA. In a best value, this doesn't apply. It's very hard to get a best value protest dismissed based on this standing issue of whether you're the second lowest or not. In an agency protest based on LPTA, are we considered an interested or disinterested party if we were not the next lowest priced offeror after the awardee? Same thing, you have to be able to knock out everybody between you and the awardee if you're the next lowest price. Only in an LPTA procurement. This does not apply in a best value procurement. It seems you will receive more information post-award versus pre-award. Can you request a pre- and post-award debrief to gather as much information as possible?
So if you are excluded from the competitive range and you think you do not want to file a protest at all, you could ask for, within 3 days of receiving the notice that you were excluded from the competitive range, you could ask for a pre-award protest, or pre-award debriefing, but then ask that it happen after award. And in that case, you would get information about why you were excluded from the competitive range, and then you would also get all the information that's required of a post-award debriefing. But as Megan mentioned earlier, you cannot file a protest about your exclusion from the competitive range if you wait to get your debriefing after award. So you got to weigh those options.
Yeah, I think deciding it, if you are excluded from the competitive range, you should always request a debriefing, whether it's pre or post award, because obviously there was something that your proposal just missed, and you need to have that information going forward so that the next time you'll be included in the competitive range. But then you have to make an informed decision about whether you want to turn that into a protest or not, and that's when you have to weigh how much information will be helpful for you to do that. Can an agency refuse to provide you the awardee price? We were told that our price was X% higher than the awardee. We asked what the awardee total price was, and they refused to tell us. Are they okay to just provide us the percent, or must they tell you the total award amount? So they, at least in a FAR Part 15 procurement, and I feel like in a FAR Part 8 as well, they have to tell you the price. I think by telling you the percent, they were essentially telling you the price, but just in a different way. So yes, they do have to tell you the price. Do you have anything else to add on that?
But you'll be in a bad situation if they refuse to provide you the price and you can't figure it out, because like we were saying, it's hard to force the agency to comply with their requirements about what they're supposed to tell you, even though they are supposed to tell you the price.
In a post-award debrief, are we allowed to know how many offerors there were and their identity? So under the FAR, you are not entitled to this information. I will tell you that I think it's likely that the agency will tell you how many offerors there were, and they will never tell you their identity. And they might tell you how many there were as a way to discourage you from protesting, that if there were 20 offerors and you were in the bottom 20, you might think twice about protesting. How do we find out about the second and third in line if we are the fourth? You said earlier that we cannot get anything on the in-between companies. Did I get this right? So when they do the ranking, sometimes they will reveal more information about the people in between, but generally speaking, you're right. You're kind of stuck between a rock and a hard place, that if they don't even give you the identity, and they're not, required to, they just see that, it's 1 million, 1.2 million, 1.3 million, 1.4 million, and you're 1.4 million, and it's an LPTA, then generally speaking, absent some egregious error in how either your price was calculated or that we could find out that the awardee was technically unacceptable, we probably wouldn't recommend that you move forward with a protest in that case, if that was your goal. What is the frequency of LPTA solicitations today? We are told that they are used less and then only for solicitation like facilities. So that is the goal, particularly for DOD, and the NDAA actually did reiterate that Congress only wants DOD using LPTA procurements for things that are, don't require a lot of discretion to evaluate. So types of services where, it's very easy for them to say, okay, this meets our needs, this doesn't meet our needs. But when it gets to be something complex, like I'm just going to pick cybersecurity. Cybersecurity is the type of procurement that there should not be LPTA bidding, because there's just the level of sophistication needed for the evaluation is such that it doesn't lend itself to an LPTA, and the government wouldn't in fact be getting the best value by doing it that way. In contrast, the LPTAs, when I've seen recently coming out of DoD, you're right, it's facilities maintenance. How do we make a call between going forward with a protest and potentially being blacklisted by the client agency in the future?
We typically don't see contractors get blacklisted just for filing a protest. I think while contracting officers don't like protests generally, I think I could say that, I don't think they hold grudges against protesters simply because they file a protest.
I agree. And we've had, clients where we protested and the result of the corrective action was that they got the contract. So, it's just something you have to weigh, a business decision of whether it's worth the risk or not for you. Do you work with state government contractors? Yes, we do. I understand that each protest is different, but what is the average cost for a protest? I can't give you an average cost. Sometimes they can be a couple $1,000s, and sometimes if they're very complex, they can be in the six figures. So there's really no average cost. Can you win the protest and still lose the award? Yes, unfortunately. That's why, we like to have very candid conversations with our clients before we file a protest, because sometimes it's throwing good money after bad. That if we go forward with the protest, there is absolutely no guarantee that the agency is going to make the award to you. I will tell you, I've seen extreme cases where we have protested, we have knocked the awardee out of contention. So there's the only possible award that can be made is to our client, and the agency canceled the procurement. So it can happen where you go through this effort and you win, quote unquote, win at GAO, and you don't actually get the contract. But, there have been plenty of other times where we've won the protest, we've won our costs for filing a protest, and the client gets the contract. So there are success stories too. What if back channel doesn't work for lack of responsiveness? And this goes back to getting the debriefing done in a timely manner. If back channel doesn't work, there's really no other channel. There's no formal legal channel to challenge the agency's delay in giving you a debrief. GAO and the Court of Federal Claims has both said that. Does this work for broad area announcements as well? And I don't know what this question could have been tied to, and the person is left. So, sorry. If you request a debriefing as a successful offeror, what sort of information is the government required to provide, and or what sorts of questions should offerors ask, which would be unique to a successful offeror debrief? This is a great question. We should have covered this. So do you have some thoughts on this?
Well, they're still supposed to provide you the same information that you would get if you were the unsuccessful offeror. But in terms of questions, you could ask for any suggestions for or any areas that are not already identified in your, so if you get a rating that says you were rated good, you might ask if you were assigned any weaknesses, just so you know why you were good instead of excellent or something like that.
I think that anytime you know what lies beneath your rating, and as good as that rating is, that would be indication of what you need to repeat for similar proposals in the future. So if they say, what we loved about your corporate experience section is that you highlighted all of the experience of your key personnel and you call it out in separate boxes on over 2 pages. That to me says, okay, well, I'm going to do that again, either for this agency or a similar opportunity in the future. I'm going to structure my corporate experience section the exact same way. So it's a chance for you to get some insight into how to make your proposals more competitive from the people who are actually reading them.
And if you are in a situation where you have been awarded a contract but that someone else protests it, it can give you an indication of whether there are any vulnerability of whether the protest could be successful.
That's an excellent point. Is there a time limit given for the agency if you ask to keep the debriefing open? No. I mean, they know that you're asking. It's to reserve your ability to protest. So they will keep it open for a very small period of time. And by small, I mean less than a week. because they want to kind of get the protest process moving so they can move forward with the contract. You have to know that most agencies, particularly in DoD, they build in the 100-day GAO protest timeline into their procurement plans because they just assume that if a contract can be protested, it will be protested. So they build that into when they actually expect performance to begin. Can you protest/request a debrief on a solicitation in which the government is taking a long time to make award? For example, we submitted a proposal to labor back in September 2017. However, they just notified us a few weeks ago that an award would not be made until October, November of 2018. No, unfortunately not. You can't protest them taking a long time to do their jobs. We could tell you some horror stories of a case that we're on right now of a procurement that we're approaching the 2-year anniversary. So it just, sometimes it happens, and I've got to tell you, sometimes it results in the cancellation. I'm not saying that's going to happen to you, but it has happened in the past where we've had clients sitting around for 2 years to hear something, and all of a sudden the solicitation's canceled. If I'm immediately rejected for not meeting test compliance, can I still ask for a debriefing? Will I be able to ask for price competitiveness? On the first question, can you ask for a debriefing? Yes. On price competitiveness, if they were not required to evaluate your price, just based on that first threshold of the compliance, then you can ask for it, but odds are they're not going to give you any information because they frankly didn't look at your price. If the DoD uses a GSA schedule for a $10 million contract, will it follow the new rule or GSA schedule rule? Ooh, great question. So I am going to say that it will follow the GSA rule, but what do you think?
Well, under the new DoD rules from the NDAA, which are not in effect yet, once they are in effect, you're supposed to get a debriefing for all awards over $10 million, whether it's a contract or a task order. So I think for a DoD task order under the GSA schedule, once this rule is implemented into the FAR, I think you would get a debriefing if it's over $10 million.
The reason, Catherine, that I'm hedging is because of protest jurisdiction. And not so much with GSA schedules, but generally you probably have heard that for a multiple award contract, when it's a DoD task order, you can only go to GAO and protest it if it's over $25 million. However, if DoD uses a civilian agency multiple award contract like OASIS to make the purchase, then it's the $10 million threshold. So that's one of those situations where DoD gets the benefit of the civilian rules, and that's why I'm wondering if that would apply here too. If you submit questions within 2 business days of a debrief and the government responds within 5 business days, but you have questions on their response, can you submit additional questions on their response if within 2 business days?
I think you could still submit the questions and ask that the debriefing be kept open, but I would not assume that it would be.
In that case, it would be exactly like it is for civilian agencies, where you can try to submit questions after the fact and ask them to keep the debriefing open, but you're not guaranteed that they'll do so. What constitutes an interested party if you are the 3rd or 4th in line? Seems like we are told if you are not next in line, you are not an interested party. Is this correct? For an LPTA procurement, yes, that is generally correct. When do you anticipate other actions from the 2018 NDAA? I think you went over this. Hopefully by this calendar year, but we're not sure. Is there ever a risk in requesting a debrief or protesting an award? Requesting a debrief, no, there's no risk at all in you requesting one. Protesting, there's the risk of the cost, there's the risk that it might not end up that you'll ultimately win the contract, and there is the perceived stigma associated with protesting. Whether that actually exists or not, I frankly don't think it does, but I'm not, I don't have to see the CO every day, and you all do, so you have to make that decision. If you submit questions within 2 business days, but the government does not respond back to your questions within the required 5 business days, what happens next? Is the protest automatically upheld? Other action. So I think that because this is a new FAR class deviation, I actually just saw an agency debrief. A DoD component sent my client a debrief, and in the email they made reference to this 2 business day questions. My strong suspicion is that the DoD procurement folks have been schooled up on this before they issued the class waiver. So first, I think I think it's going to be unlikely that you're not going to get responses within 5 business days. And frankly, even before the class deviation, when agencies did hold the debriefing open and let contractors submit questions, 9 times out of 10, they gave the answers within 5 business days. But if for some reason they did not, then you need to move forward. I would suggest move forward with filing the protest, and you should not assume it will automatically be upheld, the timeline of it. What if they refuse to tell you things that they are required to provide? Seems like there is no recourse. Yes, I agree. Unfortunately, there is no recourse if they do not tell you things they are required to tell you in the debriefing. GAO and the court just reason that debriefs are for essentially they say that it's an administrative act and it's, not really meant to give rise to any kind of dispute.
Yeah.
NASA tends to release public source selection statements. Have you found those to be useful in conjunction with the debrief? Yes, absolutely. Not just NASA, but anytime we get the redacted source selection statements or decisions, I find that very helpful in counseling clients on whether to move forward with a protest or not. And that's why I think it was very smart of Congress to include that as part of the enhanced debriefing. Are the NASA source selection statements similar to what the NDAA is requiring of DoD? Yes, I anticipate it would be very, very similar. Clarification. Did you say you are excluded from the competitive range and request a post-award debriefing that you cannot protest the basis of the exclusion? So yes, it would be untimely. So if they give you an option, if you are excluded from the competitive range, and agencies will do this because they'll try to trick you. They will say you've been excluded to the competitive range. You can request a pre-award debriefing, or you can request a post-award debriefing. And companies sometimes think if they wait for the post-award, then they will get more information. But what GAO says is that you've basically sat on your hands and not exercised your right to file a protest, because this gets into the timeliness versus the stay, but generally to file a protest, it has to be 10 days of when you knew or should have known of your protest grounds. So that notice of exclusion starts that clock. Do you need an attorney to protest? That person has left, but the answer is no. You can file a pro se protest. The problem is that then you won't have a protective order put in your place, and that you will be excluded from some of the source selection material, and your attorney can access that material. Remind us of where the slides are for today's seminar. They are in the handouts section of the GoToMeeting. On our screen, that's to the left. I don't know where it is on your right, on yours, but it's in the handout section of the GoToMeeting, the slides. You can also go to our website, polaramaza.com/presentations, and they'll be available there. And the last, it's not really a question, it's an observation. There is a recourse if you don't get the required information. You can go to your congressman or senators, and they will get it for you. So that's a good tip for everyone. And with that, we will sign off. Again, this is Megan Connor. My email address is on the screen. Feel free to reach out with any questions. And Julia, do you have any closing remarks?
No.
Well, thank you all so much for attending. Have a great day.